last case to come before the court this morning is Isiah Daniels versus State of Ohio. That's all I say, Daniels versus State of Ohio, State Teachers Retirement System. Sorry, there's one. We've not had to waive his argument in this matter, and only the athlete will be arguing, so there's not, you're not going to have to change it any time you read the public. Are you both going to be arguing this morning, or just one?
Yes, we need to change, to split the time.
Okay, and how are you planning on dividing the time?
I'll go first.
Okay, how many minutes are you going to be using? Or are you just going to go till you're done and then she's taking over? How do you want to split the time?
I can use, I don't anticipate on even using half of it.
Okay, thank you. Again, we are being visually and audibly recorded, so please try to remain behind the podium as much as possible. We have read the briefs and we're ready to proceed with the argument.
Thank you, Your Honor. May it please the court, my name is Mary Therese Bridge. I'm an Assistant Attorney General, and I'm here today to represent the State Teachers Retirement System of Ohio. And as I said earlier, I'll be splitting time with Melissa Graham-Hurd, counsel for appellee intervener Cecilia Maldonado. Isiah Daniels made a choice that was final, and now he's searching for a reason for it not to be final. When Isiah Daniels applied for retirement with the State Teachers Retirement System of Ohio, he had to choose which retirement plan he wanted. He selected a joint and survivor annuity plan of payment, option 2C, with a 15-year guarantee, and 1/2 of the benefit amount continuing after death to his primary beneficiary without reversion. That meant that the payment plan could never revert to a single life annuity, and he could not change the primary beneficiary. Daniel selected the plan described in Revised Code Section 3307.60A2. Daniels designated his then spouse, Cecilia Maldonado, the appellee intervener in this case, as primary beneficiary. Daniels and Maldonado divorced, and now Daniels wants to change his primary beneficiary designation. According to Ohio Administrative Code 3307-8-01, selection of a plan of payment becomes final on the 15th day of the month of the first regular benefit payment. After that, no change may be made in the plan of payment selected. Daniels has mentioned that Revised Code Section 3307.60A3 provides that he should be able to change his beneficiary. However, Revised Code Section 3307.60A3 does not apply here. Daniels chose the plan described in Revised Code Section 3307.60A2 as his retirement plan, not the plan described in Revised Code Section 3307.60A3. Daniels has also mentioned that Revised Code Section 5815.33B1 allows him to name a new beneficiary after the divorce. However, Revised Code Section 5815.33 is from the Revised Code Title and Trust and does not apply here. STRS was created by the General Assembly and is governed by the statutes in Revised Code Section 3307. Daniels was informed of the aspects of the plan, including the positives and the possible negatives. He was told that one of the aspects of the plan he chose was that the primary beneficiary could not be changed. He selected a plan that specifically indicated it was without reversion. Appellant cannot change the primary beneficiary now. In conclusion, this court should affirm the Common Pleas Court's decision dismissing Appellant Daniels' petition for writ of mandamus. Thank you.
May it please the court, I'm Melissa Graham-Hurd. I represent Cecilia Maldonado, who is the intervener in this action that was filed in the Common Pleas Court on a writ of mandamus filed by her former husband, Isiah Daniels, to change the provisions of the retirement aspect. I did represent Ms. Maldonado when the parties divorced. The only aspect of the divorce that was not agreed upon and not stipulated was his request, Isaiah's request, to change the beneficiary of his STRS pension. By that time, he had been in retirement pay status for over 11 years. As your honors are aware, under the revised code, which STRS is a creature of statute and has to only do what the code allows it to do, you can only make a change within so many days after the first payment is received. That had long passed by the time the parties divorced.
Counsel, I have a question, and I saved it for you because I realized that you had been a part of the divorce proceeding. From what I read here, it seemed to me that the magistrate actually outlined what I would say in detail, the fact that he chose A2 and that it was without reversion. Is that correct?
Yes, your honor.
Then what I'm not understanding is the line from the court's adaptation, and you're looking like maybe you didn't either, that basically is what Mr. Daniels is relying on. They almost seem contradictory to me.
Except that, putting oneself in the magistrate's shoes, who was not called upon to determine the rules governing STRS and only governing the issues in the divorce case between the wife and the husband. Giving the benefit of the doubt, it was perhaps, can we say, inartfully stated, but nevertheless referred to the plans, rules, and regulations governing STRS. It's not that the magistrate was unaware. I've attached as Appendix D the exhibits concerning this issue that were presented to the trial court at the time of the hearing before the magistrate.
Actually, I was questioning more the judge's ruling than the magistrate's.
Yeah, the judge's ruling just, again, that was, nobody objected. So it was the ordinary cover page. If nobody objects, here's the judgment of the trial court, and also incorporates then the decision of the magistrate. So it's the same wording, it's prepared at the same time. So nobody objected and nobody appealed that, because from our perspective, that was a correct statement, that pursuant to the rules and regulations of STRS, if they let him, he can. But we knew that he couldn't, because we were familiar with 3307.67, and we had presented in the D appendices, an Appendix D36 and Appendix D21. He had 3 options in 2005. He chose the option that was without reversion. You can't ever go back once you hit pay status. His argument that 3 means 1 and 2 can be changed because the wording is calculated as 1 and 2. I think the legislature meant calculated in the same manner when it said established as, just like. Because there's an actuarially adjusted amount, which is different between option 1, single life annuity, option 2 with a survivor at some percentage, and option 3, a survivor some percentage, but it can't ever be reverted, and then the 15-year guarantee to Isaiah's daughter if both he and his wife predeceased her during that 15-year period until 2020.
If a different option would have been selected, would the resolution of the divorce been the same?
No. No. Had there been a possibility of STRS being able to be undone, and given the age difference between Cecilia and Isiah, it really would have been a different outcome. Those things that had been stipulated to, in my opinion, having been involved, would not have been the same resolution, because that taking away the ability to receive retirement income after her husband's passing, and given the age difference and the diminution in that dollar amount, it would have changed things significantly, either through spousal support or property division, but it was part of the entire scheme of things. So when Isiah asked the Common Pleas Court to order STRS to do that which was impossible, the Attorney General's office rightly filed a 12B6 motion saying you can't state a set of facts to support your claim, you can't do it, and the trial court judge was correct in the ruling. So we would ask you to affirm the trial court's ruling dismissing the writ of mandamus in this action. I'd be happy to entertain any other questions that you might have, and thank you for your time.
Thank you, seeing none. Thank you for presentation.